Hey, what's going on, everyone? Fuentes here. I'm back with a real talk update on the Linqto Bankruptcy. If you're new to the channel, I'm a Linqto customer and a former Linqto employee, and I'm appearing pro se in this ongoing Linqto Bankruptcy case. I care about the platform and I care about the people who believed in it. What you'll hear today is my view based on documents and firsthand experience. It's not legal or financial advice. Please talk to your own counsel. I spoke at the recent hearing this week after listening to much of the questionable information being broadcasted to the general public by Linqto's current management and John Deaton during their recent X Spaces. It felt important to me to stand up, put my name on the record, and say clearly what many of us are saying privately. We invested series by series through SPVs that were presented to us, having a one-for-one pass-through to the underlying shares at a liquidity event. That was the bargain, that was the promise. And right now, there are proposals floating around for a liquidation trust here, a closed-end fund there, which in my point of view puts our one-for-one expectations at risk, especially when understanding that we invested in late-stage, high-growth private companies. These aren't a basket of penny stocks. These are specific assets we chose one series at a time. Let me translate the structures that are currently being proposed as bankruptcy solutions by Linqto's current management team, which is then endorsed and encouraged by the class actions attorney John Deaton. Let me explain in plain English. A liquidating trust is designed to wind things down and return value. Yes, it can distribute stocks in kind if the plan says so and it makes sense, but in practice, this structure often cashes things out. A closed-end fund is designed to pool assets and give you exposure to an overall portfolio. It can distribute shares too, but that's even rarer and it usually ends up in cash. The bigger point is the psychology here, the information you're being drip-fed. It's not by chance. If Linqto's current management says that they're on our side, willing to give us our shares on a one-for-one basis, then put that in writing. Don't hide behind some song and dance or some strange story about your dogs. Let's talk about the facts here, which leads me to another practical choke point that doesn't seem to be getting enough attention here, and that's the current SPV manager's authority. Right now, a lot of the power sits there over the series assets, cap tables, and distributions. That's where the lever is. If we leave unilateral control in place, we risk seeing our series rolled up, recharacterized, or just slowed down to death. I asked the court to address that directly, replace the current authority of the SPV manager with independent court-supervised fiduciary oversight, reconcile every series against the transfer agent and custodian records, and make sure the one-for-one delivery is by default, not something you have to go hunt for by checking some box. Meanwhile, John Deaton and Linqto's current management want the boxes for the closed-end funds to be checked by default for the non-accredited investors and unsecured creditors who have yet to file their claims. Sure, this may have been voted by the Unsecured Creditors Committee, but guess who's echoing this with their influence? Now let's talk about the information quality. I know X Spaces have been popular lately, but social audio is not sworn filing. If someone says, "We're suing this person," but their engagement letter doesn't actually state that person's name, that's a signal to slow down and read carefully. I'm not attacking anyone here. I'm just saying, please trust the documents over sound bites. Verify before you amplify. A lot of you have asked what I did when filing on a pro se basis. I kept it simple and factual. I filed my claim with a letter reserving my rights, plus a spreadsheet that listed what I paid versus what the estimated unrealized value is, using observable markers where they exist, like Circle's price after they IPO'd or Ripple's recent buyback indications at $175 per share. I also attached evidence of what I bought were series SPVs with economic rights to the underlying shares at liquidity. And please hear me on this. Make sure you redact your personal information. The bankruptcy court's documents become public records. And if you don't redact your personal information, you'll end up getting solicitations from claims buyers. I call them claims vultures. People trying to buy your distress for pennies on the dollars. Be careful. So what I'm actually asking the court to do is honor the original bargain. Require a series by series reconciliation. Platform ledgers must match the records at the transfer agent or custodian, share for share. Draw a bright red line between the company treasury positions and customer assets. It's time to bring Linqto's corporate treasury to the forefront. Linqto's sitting on a massive corporate treasury. Appoint an independent SPV administrator or trustees with real controls. What I mean is multi-signatures for movements, policy limits, and audit trails. Call them transparency pages. And stop the forced pooling. If someone truly wants a trust or a fund, let them clearly opt in. Don't implement these options by default. There's also a cleaner, more faithful route than a trust or fund or else. We can restructure the SPVs series by series, consistent with governing documents. If we need to, we can domesticate or convert the existing Delaware series into Texas recognized series LLCs, which is where the bankruptcy case is filed, in Texas. This approach keeps the legal architecture aligned with the product that we were sold. Regarding the costs, I've asked respectfully that legal administration expenses be paid from Linqto's treasury, including the Ripple-related proceeds referenced by the former leadership, not from customer funds. If the goal is to restore trust, the path should be the most efficient and least dilutive to the people who funded these series in the first place. Let me address the social media part of this head on. I've seen posts and consensus narratives forming in real time. Here's a recent Twitter post from John Deaton resulting from our civilized back and forth discussion on the topic of Linqto's bankruptcy. John Deaton confirms Linqto is in violation of the following exemptions: unregistered broker-dealer activity, excessive markups, fraudulent securities offerings, non-exempt and registered securities offerings, and non-exempt and registered investment company. Here's a recent clip from John Deaton's recent X Space discussing the excessive markups.
All right, for the people out there that are saying that, I already addressed it, that there is no fraud, that's crazy. Also, people are out there saying that, oh, so what, Bill Sayers charged 60%. My Ripple shares are eightfold now. You could charge 100%, dude. Just tell people. It's called transparency. The rules require, the law requires 5 to 15%. But if you're going to go above that, you're in violation of FINRA. You're in violation of the Securities Act, unless you tell people, hey, by the way, I'm going to upcharge you 60%.
That's literally what I said in my video last week. The front-end upcharge is not too much of the concern here. However, transparency moving forward is the key. Regarding the claims related to unregistered broker-dealer and non-exempt unregistered securities offerings, let's see how the courts treat Linqto and the Reg D exemptions. If we're talking about the restructuring of the very fabric of the private capital markets, my money is on the government strategically allowing it to flourish in the private sector before stepping in and regulating the market, as we're seeing right now. I have no insights into this. I'm just speculating and proposing thought-provoking questions. And for the record, I have nothing against John Deaton. I believe he's a good man, a family man, a white knight of the XRP community, and I'd gladly have him on my channel any day of the week to have a civilized chat, because I don't really understand what his role is in this Linqto bankruptcy process if his focus is on suing the former CEO as an individual. I'd really like to better understand why Linqto recommends to follow John Deaton during its darkest hour. Now, if you're someone who's uncomfortable with my questions, my content, you don't need to watch. Just sign your name on the dotted line for the Liquidating Trust or closed-end fund and change the channel. But if you're someone who's unsure about getting pigeonholed into some class action lawsuit, or if you're unsure about having someone else representing your bankruptcy claims, especially after they send out mixed messages about defendants or outcomes, you have more power than you think. You can file your own claim with your own counsel or on a pro se basis like I did. You can stand up and say, no, I didn't buy a fund, or no, I don't want to end up in a liquidation trust. I bought a series by series SPV with a 1-for-1 pass-through, and that's what I expect to receive. I'm going to leave you with this. I believe in democratized private markets just as much as I believe in keeping promises. Yes, I'm a customer, and yes, I'm a former Linqto employee. Those identities don't conflict. They sharpen my responsibility. We want our shares on a 1-for-1 basis because that's what we were sold, and that's what we promised to our global Linqto community. Otherwise, I would never have allowed Linqto to use my face to humanize their platform for the years that I was at the firm. We're prepared to fight through the appeals process and potentially all the way up to the Supreme Court if necessary. This case is very unique and could set precedents not just for the accredited investor rules, but for broker-dealers, tokenized offerings. We'll just have to wait and see. If this video helped you, share it with someone who's confused by the noise. Keep your records tight. Subscriptions, series names, units, payments, emails, offering docs, you name it. Redact your personal identifying information, ask for receipts, and remember, documents over soundbites. I'm gonna keep showing up, I'll keep fighting, and I'll keep you posted. Thanks for tuning in. Love you mucho.
Again, for those of you who don't know, I'm Dan Siciliano. I'm the CEO of LinkedIn. I came in January of 2025. We're going to keep this spaces pretty short for a couple of reasons. One, John Deaton's doing one at 3 o'clock Pacific time, and so I don't need to go long. He's even better, way better at explaining some of this stuff than I am, and he may even have more cutting edge information. So we'll keep our part short and to the point of the stuff that we know best. And secondly, I think there's still a lot of stuff happening. Tomorrow there is a hearing, but it's actually just kind of a check-in. And I'll mention a couple of reasons why stuff has been delayed, at least so far as we understand it. And so we'll talk a little bit about that. John Deaton's filing in his class action lawsuit against Bill Saris, the previous CEO, does a good job of hitting a lot of the highlights, not all of them, but a lot of the highlights. If that's of interest to you, I would suggest going and taking a look there.